All right, good afternoon, everybody. Thank you all for tuning in. My name is Rob Del Giorno. I'm here with my partner, Peter Hoffman, and we have a great presentation for you today. We're very excited to kick off Garfunkel Wild's compliance webinar series. It's going to be a monthly series. We're going to do it at lunchtime, so you don't have to take too much time out of your day. We think it's going to be a great place and a great space for compliance officers, providers, compliance staff to gather, get some education, have a forum to discuss issues. And if there are topics that are interesting to you that don't come up as we keep publishing our topics, please reach out to us. You can email us directly, and we'll be happy to look into and see if we can accommodate your requests. Our next installment is going to be on January 19th, and I know we're covering a topic that most providers and compliance folks overlook, and that has to do with what your compliance program obligations are under your managed care agreements. Everybody I talk to, I've done polls and talked to clients, and they're really not aware and on top of what those obligations are. So come on back in January and tune in, and we'll be happy to walk you through those things. So here we are. We've got 11 days left in the year. It's December 20th. And we've put on the topic of New York's compliance program and the proposed regulations. So why now and why this topic? And frankly, Peter, my phone, and I'm sure yours, has been ringing off the hook because, all right, they came out in July and there were comments due by September. But the truth is the majority of the compliance officers I'm talking to, the providers I'm talking to, have told me, look, I just put it aside. It came out. I knew it was a big deal, but I knew it was going to take a while. So I kind of didn't pay attention. But I'm planning for 2023 now, and I'm starting to sweat a little bit. And what do I need to know? I know it's not done. I know it's not finalized, but can you hit the highlights, remind me what they're doing, and tell me what you think? So I think it's a great time as, you know, the winter's upon us. It's time to prepare. It's time to reset. And, you know, for me, some of the big takeaways really are, look, the OMIG did not pull all their education down and have been up there and their guidance down and put this out for nothing. They're coming with something. And we were in touch. You're in touch with OMIG. I'm in touch with OMIG as early as this morning. And we're told, you know, it's coming out as soon as possible, or, you know, whatever that means. But to me, I'm looking at this saying, all right, here we are now. We're looking at a lot of minimum standards, a little bit regardless of your provider type or size. We're looking at a lot of compliance being mandated to come down from the top to really resource and fund that compliance program, make sure it's integrated into your organization. But the thing that really stood out to me, and I'm interested in hearing you on it, is, look, they tied this to as a condition of payment. So we know they mean business, and they're looking for this. There's a lot of things when you tie conditions of payment, not just a participation, to what that can mean for enforcement and things of that nature. So you've seen the changes in the involvement of compliance over the years, and so many of our friends and clients are on here. What do you see this as before we kick into the actual material?
Yeah, I think from an overall perspective, Rob, that, you know, we've seen over the years many new statutes and regulations be issued. And from my point of view, there's a natural evolution. So when you have a new law like compliance came out, 10, 12 years ago at this point, there's an introductory stage. It's new to all the providers. The providers, after being stunned by it, kind of fall back, figure out how it applies to them, figure out what they need to do, and start putting things in place. At some point, you then move from that introductory stage to an educational stage, and we've seen that with compliance. OMIG came in, for a while they had up on their website compliance effectiveness reviews, and they would do effectiveness reviews at certain providers. But those were mainly educational in nature. It was, hey, you're missing this, and hey, you got to do that. There was no punitive, there was no punishment for providers who were out of compliance. It was, hey guys, you got to do this, let's fix that, and we'll move on. The third stage in any new statute or regulation is enforcement. And I think these proposed regulations are a harbinger of enforcement. They're much more detailed, as we'll go through, and I think once they're in place for a while, so If they're issued in the first part of next year, there's a 90-day grace period. You know, you're getting towards the end of 23, early 24. I think you're going to start to see enforcement actions where OMIG comes in and looks at a provider and says, okay, not only do you not satisfy and we can tell you where you're deficient, but we have the ability to impose penalties. We have the ability to even exclude you from the Medicaid program, take back claims, because as Rob said, it is a condition of payment. So I think that just the issuance of these proposed rules is a very important moment, as I see it, in a transition from the educational phase to a harbinger of an enforcement phase.
Yeah, I totally agree. And so as you're planning and as you're going through these things in the coming year, what are you going to need to be doing? You're going to need to be thinking about, okay, how are we going to need to revise our policies? What additional things are we going to need? You're going to need them. And how are we going to be implementing this? And, you know, you have people around you to help you. You have, you know, people like us to help you. But let's talk about what's going on out there and take you through it so that you at least feel comfortable about it. By the way, I see the question already up. It's a question with every webinar, so thank you for the reminder. After this is done, for everybody who registered, and the registration was off of the charts, to be honest with you, so everyone's interested in this, is we're sending out the video, we're sending out the slides. So if you couldn't make it, or you want to tell your colleague couldn't make it, we'll be sending this out to you after we're done. So back in July, OMIG published the proposed changes to the compliance program regulations. They're substantially more detailed, and when they're finalized, they're going to replace the existing regulations, which frankly we're not dense in any way, not specific, and offered a lot of flexibility. So like Peter said, the enforcement will not incur until 90 days after the effective date. So let's, you know, like I said, now it's time for preparation, and your preparation is the key to success. So here are the highlights. There are significant new definitions and additions. They have updated the required providers, and we'll walk through that, including what a substantial portion of your business operations is defined to be. They've expanded and clarified who affected individuals are. Your risk areas have been expanded, and you'll see that's actually tied to your affected individuals. They have now defined what it is to have and what it means to be an effective compliance program. There's also now a concept introduced called organizational experience. And I look at this as kind of like, you know, raising our children to be, you know, teenagers and then adults. You can't just be the same year after year. They're going to look at you for growth over time and expect to see that growth in your compliance program. You have compliance officer responsibilities are now really detailed, as long as your, you know, obligation to have a committee and what their requirements are. There are new policy and procedure requirements. We'll walk through some of those. There's new contract requirements, meaning when you're out there contracting with your, you know, what they'll call affected individuals, there are provisions you're now going to be required to have in your contracts. And there are record retention requirements, as well as the new self-disclosure regulations. The required providers, a lot of this is the same, but there are some new things in here. So if you're in Article 28 or 36 under the Public Health Law, or Article 16 and 31 under the Mental Hygiene Law, you're a required provider. They've really tied in, not for our discussions today, but the MMCOs here, the Managed Care Organizations, has been a big part of this as well. And then any person for whom the Medicaid program is, or is expected to be, a substantial portion of their operations. So what is that? Okay, so now we're seeing a material change to the definitions. They're proposing to increase this from $500,000 to $1 million. They say this should, you know, make this applicable to less providers. I'll believe it when I see it. But so when a person has claimed, or could be reasonably expected to claim at least $1 million in a 12-month period, or you're expected to receive that amount in a 12-month period, you are a required provider under the new regulations, and you have to have an effective compliance program. Affected individuals. This helps to define who the compliance program must apply to. And this is a very important definition, obviously. So under the proposed regulations, all persons, individuals or entities, are affected by the required provider's risk areas, including your employees, your chief executives, your senior administrators, managers, your contractors, agents, subcontractors, independent contractors, and then again, always, you'll see this overlay is the governing body and the corporate officers. They really want things to ensure that this is applying to your folks at the top. But they're sending clear guidance now on the breadth of your compliance program. And you have to really be looking at your vendors, your 1099s, your service organizations, okay, and determining, okay, are they getting touched by your risk areas? If so, you have obligations as it relates to them. And your compliance program applies to them. So risk areas, these have been expanded. Okay, the risk areas, these were laid out in the auditing and discussed in the old regs, but here we see some expansion. So we have billing, payments, and now we have ordered services. Okay, that's new. Medical necessity, quality of care, governance, mandatory reporting and credentialing. And again, here you go. Your contractor, subcontractor, or independent contract oversight. I'm hoping that after all of these comments went in, and the questions went to OMIG, that we're going to get some clarity here, because we really need to understand the level of oversight they're going to be expecting from our clients and providers out there as it relates to these. But this is weaved throughout. Other risk areas you should know about based on who you are as a provider, but through also this organizational experience. Okay, so again, based on how you've grown over time, they expect you to have a more in-depth look at what your risk areas are. And then, of course, there's stuff related to the MMCOs.
So,
turn this to Peter. Go ahead.
So Rob has talked about a couple of important new definitions, and I think for those on the phone looking for takeaways, affected individuals is going to be a key term you're going to hear throughout, which Rob defined earlier. Organizational experience, which I'm going to talk about in a moment, is another key term that you're going to want to take away. And I see someone has already posted a question, which I'm happy to weave in. Can you please go through the requirements for communications with and training of outside vendors? That's all tying to these definitions. So we'll touch upon the training in a moment or down the road a little bit. But you are going to have responsibilities because they are affected individuals under this new definition and under the new proposed regime. The other key term, from my perspective, is this organizational experience. And the way it's defined, you'll see up on the slides, is your knowledge, skill, practice, and understanding in operating the compliance program, your identification of issues or risk areas that result from your internal monitoring, your experience, knowledge, skill, and practice, particular to the Medicaid program. Remember, this is, at its essence, a Medicaid requirement, the results of any audits, investigations, or reviews, and kind of a catch-all here, awareness of any issues that you should have reasonably become aware of for your category or categories of service. So what does that mean? It's a lot of words, a lot of legalese. To me, the takeaway for organizational experience is what you've learned or what you should have learned based on what you do. And all of that needs to be incorporated into the compliance program. Another new important definition is they've actually laid out a specific definition of an effective compliance program. Effective generally in the past we would define as meeting the regs. That's still the case. You'll see here that they've defined it or proposed to define it as adopted and implemented by the provider that at minimum satisfies the proposed regs and is compatible with your characteristics as a provider. But they've gone a little bit further, and they said it has to be well integrated and supported at the highest levels. That's something we've always recommended. You need top-down buy-in. And that has to include your CEO, senior management, and of course the governing body, such as a board of directors, board of trustees. The program has to promote adherence to your legal and ethical obligations. I think most of you with active compliance programs tick that box off. And it has to be reasonably designed to prevent, detect, and correct non-compliance with Medicaid requirements, including fraud, waste, and abuse, most likely to occur for your risk areas, which we went over before, and here's that term again, your organizational experience. So it becomes a lot more detailed and a lot more individualistic to what you're doing. They're trying, in my view, to move away from the generic, we found a compliance program online, we copied it and pasted our name on it, and it's sufficient.
I agree. And the one thing I'll say about that too is, like, I lived with the OMIG and on a corporate integrity agreement for about 4 years with a provider.
Yep.
And I'm seeing a lot of what the expectations were, not just in those agreements, but also in what my daily conversations were with them. And they were really excellent in being transparent about what they expected to see. But this growth was one of them. If an issue repeated itself, they want to see that growth over time. If these are things you should be catching, this happened a few times before. You've gone through this already. So
I think that's
they
exactly
really want
right.
to see that.
I think that's exactly right. And they want to see that you're focusing not just on the general 35,000-foot view of compliance, which I think everybody at this point has down pretty good, but how it specifically ties to what you do on a daily basis. One of the other really important areas that they've proposed to define here is also compliance officer responsibilities. I talk on a weekly, if not a daily basis to my compliance officers, as I know Rob does as well, and you often get the question, well, what is it exactly that is in my scope and what isn't? Well, OMIG is now given a little guidance here, and they're laying out with some specificity the primary responsibilities of the compliance officer. So let's kind of tick through them quickly. Oversight, not unusual, right? Not surprising. You're, as the compliance officer, responsible for overseeing and monitoring that the program has been adopted, that it has been implemented and maintained, and for evaluating its effectiveness. Work plan. This is an interesting one. We recommend to our clients work plans every year. I will tell you that it often gets done, and sometimes it doesn't. It is now being made clear that no less than annually, or as otherwise necessary, you must draft, implement, and update a work plan that meets any changes to your elements, to what you do as a provider. And you have to outline in that work plan what's your strategy to meet those requirements for the coming year. And there are certain things emphasized in the proposed regs, which we won't go into detail today, about training and things of that nature. The compliance officer is also responsible to review and revise the program and the policies and procedures and standards to incorporate changes based on your organizational experience. And there's that term, once again, your organizational experience, what you do, what you should be doing based on your particular areas.
Yeah, I think that work plan, get that work plan going. It's going to be the first thing, one of the first things they're going to ask for is, let me see what you're doing. Give me the roadmap to how you handle your compliance program this year. So that's a really important tool that you really can have to help, save you. And hopefully, if you're not doing it, it'll sink you.
Yeah, and that it's up to date, right?
Yeah.
So it can't be, well, we do the same thing year after year after year. Regular reporting, more of the compliance officer responsibilities here. And this is also something that I want to draw your attention to that may require a change. The reporting directly and on a regular basis to the governing body is nothing new. That's always been part of a compliance program. It's always been recommended, and including the CEO, the compliance committee on what you're doing, how it's being adopted, how it's being implemented, how it's being maintained. The proposed rules are now saying this has to occur no less frequently than quarterly. So for those of you out there who report to the board once a year, this is a real change to take notice of, okay, to the extent that it goes into effect. A compliance officer is also on the hook for establishing methods to improve your efficiency, your quality of services, and reducing your vulnerability to fraud, waste, and abuse. You have to investigate and independently act on matters relating to the compliance program, including figuring out how to do internal investigations, how to document them, how to report on them, which we'll talk about more in a few minutes, and coordinating and pursuing, the most important thing, corrective action. And we're going to pass over the MCO stuff because I don't know that we have a lot of folks on the phone to whom that's relevant, but MCOs have additional responsibilities as well. Compliance committee, a huge area. Most of our large clients, institutional clients in particular, have a compliance committee. It's formalized in the proposed regs, and its overall responsibility is to coordinate with the compliance officer and ensure that things are being done in an ethical and responsible manner. Some new things to note. One, compliance charter. Your compliance committee, if the proposed rules go into effect, needs a written charter. That charter will need to express the committee's duties and responsibilities, its membership, who the chair is, and the frequency of the meeting. And that charter will need to be reviewed and updated at least annually. One kind of practice tip here, you want to make sure in your bylaws that the creation of a compliance committee charter is consistent with the way you're structured as a corporate entity. You don't want them going off on a frolic and detour. That's not a big change, but it may be a technical change to be aware of. Who has to be on the compliance committee? To date, the proposed regs only say at minimum senior managers. So there's some flexibility in there. And again, something that may require a practice change for those of you on the phone, the committee has to meet no less than quarterly. We early on, and we've been doing compliance programs for 2 decades or more, they would meet monthly. Some providers said that that wasn't very productive, moved to quarterly. This is making clear that it can be no less than quarterly, and that the reporting lines have to be accountable to the chief executive and the governing body. A few more things on the committee's responsibility, and some of them are really interesting. Policies and procedures, standards of conduct, the committee has to have a role in ensuring their responsibility, same for training. Communication and cooperation by affected individuals, and there again is that term that's outlined earlier, on compliance issues, on audits, or on anything else. And in talking to my compliance officers, this is the one that got the most attention. The compliance committee is responsible to ensure, and that's OMIG's terminology, that the compliance officer is allocated sufficient funding, resources, and staff to perform their responsibilities. And I will tell you that I understand the intent of it. I think the OMIG's intent is well taken and in good faith. I think placing that responsibility at a committee level, even a board committee level, is something that's going to be difficult to achieve. A couple other things quickly. Effective systems, effective policies. These are things that they want the compliance committee to coordinate on and enacting required modifications. So what you're seeing here is the establishment of clear lines of authority. The compliance officer working in conjunction with the compliance committee, reporting up to senior management and the board, and essentially establishing that dotted line on a table of organization. something that we've recommended but hasn't been clear in the regs in the past.
Yeah.
So
All right.
let me turn over to Rob, who's going to talk a little bit about the policies and procedure requirements.
All right, great. So seeing things pop up on the board, we're trying to, we encourage the questions, keep them coming. The slides, will they be made available? Yes, they will be made available along with the recording. They'll be sent out. So you can have them. We also have a smart question asking about risk assessments, showing somebody who's obviously, we know, but is sophisticated as it relates to running an effective compliance program. If we don't get to it by the end, because the risk assessment is a little bit more nuanced, because it really is provider type driven, we can try to reach out to you directly afterwards. So thank you. Keep the questions coming. So written policies and procedures, more specificity. And you have to include a process. So now we need a document talking about our process for having policies and procedures, okay, so more and more, policies that we need here. So we have to lay out what's our process for doing this. They must be available, accessible, and applicable to all of our affected individuals. Not a great change there, but they're making sure that you're covering everybody and that this is actually something that's not sitting on a shelf collecting dust. You have to articulate your commitment and obligation to comply with applicable laws. Think of these, and there's stuff in there about our standards of conduct that we'll get to, but here's a change and an important one, and this is where you're going to really have to have the rubber meet the road a little bit when you're updating your policies. They want, as it stands now, and if it's adopted as it is, identify the governing laws, regulations, and including Medicare program and policies or rules, think about your manuals, applicable to your risk areas. So, having general discussions about things like anti-kickback statute or False Claims Act or whistleblower law, these types of things, not enough. Talking about billing or what you're doing, not enough. They're going to have to get into a little bit of the weeds because they really want, I think, overall, this document to serve as an educational tool and provide guidance to the employees.
Yeah, and I think that one in particular is a large task. I think, institutions like a hospital may have a leg up because they often have very specific policies and procedures, whether that's in accordance with Joint Commission or just their hospital policies and procedures, that to the extent they're not, can be worked into the compliance program policies and procedures. But it does go back to that earlier point of what are your risk areas, what based on your own experience, and they want that level of detail, it appears.
Yeah, think about if you're doing if you're a mobile, provider, you're going to have things in there about that. If you're a DME provider, you're going to need to be focused on what are those regs on there. If you're a laboratory, you're going to need to have things related to kind of the specific testing that you're doing, just like the easy one is like the tox, the screening versus the definitive. You're going to have to get in the weeds a little bit here. And so you have to have a formal standards of conduct. That's a ground ball. And if you have a compliance program, that should be the first document. It's our first, and your commitment to engaging in an ethical manner. You also have to document the implementation of your compliance program requirements and outline its operation. So you're going to have to sit down and have another document, whether it's our process for how we're drafting, but how are we going to carry our program out? And you're going to want to make sure that's a tool that you can follow, because the worst thing you want is a regulator walking in, grabbing it as a checklist and just docking you on all the things you said you were going to do, but you didn't do. And then you have to describe your program structure. That's pretty easy. And the responsibilities of your affected persons to carry out the function. I think those are pretty straightforward things. And here we are, and this kind of ties to what I was alluding to before, providing guidance to your affected individuals. You really need to assist them on identifying compliance issues, and how they can bring them to the appropriate people, whether it's a compliance officer, committee members, you have to really explain that in your documents. You have to explain what your expectations are, that they're going to follow the code of conduct and not engage in illegal conduct. Again, identify those methods and your procedures for reporting and tell them in our program how we're going to resolve these issues. And of course, this one always got hammered anytime I had a client getting audited was, where's your policy on non-intimidation and no retaliation?
Right.
They've been all over that for years, and so no surprise to see it there. Disciplinary standards. We have some new things here. You have to have a written statement setting forth your required provider's policy regarding your affected individuals who fail to comply. So here's where it gets a little bit different. Your statements need to establish the degrees of disciplinary actions for the required provider that you're going to take as it relates to intentional, versus reckless versus other types of conducts, with that intentional and reckless behavior being met with more significant sanctions. And it can go anything from your typical oral warnings to termination. They also need to outline the procedures for taking your disciplinary action and sanctioning individuals. And it needs to conform to to those of you who have collective bargaining agreements. And I recall, I don't know that I wrote it here, but they were pretty clear on this, and I might cover it in another slide, is that this is applicable all the way to the top. You can't have a different disciplinary standard for your CEO than you have your nurse on a floor. You must comply with the Deficit Reduction Act. For those of you who don't know, it's federal law. If you hit certain monetary requirements, you're required to have policies regarding False Claims Act, and maybe some things in your employment handbook. Well, they're saying we don't care about the limit. If you're required to have a compliance program here, you're required to have to comply with that law. There's things in there for the MMCOs, and then we also have a mandatory review of annually to determine whether it's being followed and effective and whether you need some updates.
So let me just,
go ahead.
We can comment, two quick comments on those slides that I know we've seen in our practice quite often. One is the collective bargaining. A lot of our institutional clients, some of the professionals, the nurses in particular, 1199 or other unions, those are things that if these proposed rules go into effect, you got to really take into account, and that's going to take a little legwork. The second is, if to the extent any of our folks, compliance officers or others on the phone are lawyers, they're imposing the DRA requirements, which is a federal law, which applies when you hit $5 million and requires some for an abuse training.
Right.
Via regulation, regardless of whether or not you hit the $5 million. I think there's an interesting legal question, which we won't discuss here, as to whether they can really make a law this way through the back door of a regulation. But if it goes into effect as is, you need to assume that you got to comply with the DRA, regardless of the monetary limit.
Yeah. And a lot of times we have some clients, it's almost easier to do it than have to worry, am I going to get close to that threshold or not? Because it's not a heavy lift for that. As I go through to the next slide to answer questions as they're popping up, yes, the recording and the slides will be shared. And the question is, should we expect that the proposed regs in their current form will be finalized? Good question. Not sure. We're hoping that they're going to the OMIG will take into consideration the comments made during the comment period. There definitely needs, in my mind, to be some fine tuning, at least around some of the edges on these few things. There's a few inconsistencies. So we're not sure, but
I think that's right. I agree with exactly your sentiment. The way I would say it is, I think by and large you're going to see most of what you have here. Whether they will tweak it around the edges and provide more clarity and perhaps eliminate some things here and there, I think we're hopeful, and I think the provider community is hopeful that they will consider doing that. But I think by and large you're going to see something very similar to what we see here.
Yeah, that was well. So that's the way I would have said it if I had another chance. That was great. So details regarding your training and education requirements, and I know we had a question a little bit about this earlier, so let's walk through here. In the proposed regs, OMIG has provided detail on what it expects for you to have effective training and education, and there are minimum requirements being imposed. It must be a part of your orientation, for new, we'll say new affected persons, right? Or promptly upon hiring and at least annually. And here are the things that it needs to cover. It needs to cover your risk areas and your organizational experience. Frankly, I'm not sure how you cover your organization. That was one that stood out to me as a little bit, maybe needed some adjustment, but it needs to cover your policies and procedures, your role of your compliance officer and the committee. Okay, again, remember, we're educating people on how we operate, how your affected individuals can ask questions and report concerns. You have the duty of affected individuals to report, conduct and come forward with it. That protection from retaliation or intimidation for good faith participation in the compliance program. You have to cover your disciplinary standards with a focus on those related to the fraud, waste, and abuse prevention. You have to talk about your response to compliance issues and your corrective action plans. What do you do? How do you investigate? How do you respond to things when they come to you? You have to cover requirements specific to the Medicaid program and your categories of service. So this ties a little bit back into what we were talking about, getting into the weeds. You have to get into your coding and your billing requirements and your claim development and submission. Okay, so we're touching on the claims going in, and then again, we mentioned these MMCO specific items, but important, you have to put it in a form and format accessible and understandable to all affected individuals. I say that because a lot of our providers, depending on your provider type, a lot of times you'll have folks who English is a second language, and we've been in a position, I referenced some of the stuff with OMIG before, where we had to go out and hire translators because we had staff who were on the floor who were touching our risk areas, and we weren't really confident in their ability to understand this kind of level of detail. And so we went out and we had to hire translators to translate portions of our compliance program and to do our training in another language to ensure we were meeting our obligations. The other thing you have to do is have a training plan. So you have to have a plan on how to write your policies. You also have to have a plan for doing your training. It's not a heavy lift, but it's something else that when they're kind of checking the boxes and looking to see, do you have effective compliance program, that's going to need to be there. So your lines of communications, and we have details here, right? So you have to establish and implement effective lines of communication to ensure confidentiality for affected individuals, okay? Again, to be honest, having lines of communication is a hallmark of a compliance program. And if we don't have one and we're not reporting things, what's the point? So your lines of communication need to be accessible to all your affected individuals and allow for questions regarding your compliance issues to be raised and to be reported. You have to publicize them. This is ground ball stuff, right, that we've talked about to our clients over and over again. Get your posters up, get your things up to make sure that they know, that your folks know the lines of reporting to your compliance officer, how to get to them, and making sure it's really available. You have to have methods for anonymous reporting of potential fraud, waste, and abuse and compliance issues that go directly to the compliance officer. I tell folks a lot too, if you're just getting into this, there's so many services out there now where you can set this up very easily. It goes, answer 24 hours, emails can get sent, they can take the message, emails can go. It's pretty easy to implement this now. You must ensure that the confidentiality of persons reporting compliance issues shall be maintained unless the matter is subject to disciplinary proceeding referred to or investigated by the Medicaid Fraud Control Unit of the AG's office, for OMIG, of law enforcement, or disclosures required during a legal proceeding. And such persons shall still be protected under our policy for non-intimidation and non-retaliation. And now we have this last one that just kind of lingered to me, and this is one that needs more guidance. And it says, if applicable, not sure when, but the required provider shall make available on its website, information concerning its compliance program, including standards of conduct. Go ahead.
Yeah, I'm sorry. And just a couple of practice points on some of these things. Historically, OMIG has drawn a distinction between confidentiality and anonymity. Confidentiality essentially meaning you know who the person is, but you're going to keep it confidential except in certain circumstances, and the language OMIG has wanted for that exception has varied a bit over the years. You see another iteration here in the fourth bullet point. Calls to your compliance hotline or use of your compliance hotline. If you are a provider who year after year says, I get no calls, you have to think about different mechanisms and different ways to publicize it and use it. Because it shouldn't just be out there, it really should be something that is being used. Obviously, none of the providers want it to be used on a daily basis, but if you're going years and years and there's no calls, that's something to take a look at. And the third part is the website. So I agree with Rob. What that means isn't clear, although I think as a firm, we always are encouraging our providers to put as much as possible up on the website, including, if needed, given the nature of your employees, your contractors, your affected individuals in different languages, whether it's Spanish or some other language that may apply.
Yeah, two things on that. Good point. And one practice point I'll say is check your compliance hotline. When OMIG goes out to audit, and I was told, a pretty funny story from someone at OMIG. Every time they went out to audit compliance program, the first thing they would do is call the compliance hotline, assuming they were able to get it, and leave a message. They wanted to see, is that being monitored? Are the phone calls being made? And he told me a funny story about it had been set up incorrectly and the phone was ringing in some unoccupied office in another building when he got there. But the point is, and I tell all of them, and log it. And log the fact that you're checking these things. It's so easy to do, and it gets you credit when people come in and look at it and say, oh, well, yeah, I'm making sure it actually works. The other thing I'll tell you on this, and this gets to the website stuff, I try to encourage clients, they fear compliance. I say, don't let compliance paralyze you. Don't let, if my employees know about this, everybody's going to call and we're going to have all these problems and it's going to be the end of the business. I've never really seen that happen with well-publicized things. So don't let compliance paralyze you. Don't be afraid to put it out there.
Agreed. In fact, I think it makes you stronger in the end.
Yeah.
Monitoring and auditing. So there's a lot here, and we'll try to march through it quickly. Proposed regs talk about effective systems for routine monitoring and identification of risks. Again, that's very similar to what's now, except you got to think about risk areas as it's been redefined. They want you to have internal and, as appropriate, external audits. And here are some of the new specificity. You want to audit your risk areas. And again, you'll go back when we send out the slides after the presentation to the risk areas as defined. And you'll see it includes your organizational experience. So you're right back to that level of specificity. You have to look for what you want to include in your work plan. You have to document and share with the compliance committee and the governing body what you're doing in terms of auditing and monitoring. And of course, this is not a new requirement, although it's new in the regs. Medicaid overpayments that are identified, and that's a term of art, have to be reported, returned, and explained, and corrective action taken promptly to prevent recurrence.
I had to move it to get, we have questions popping up, and I wanted to make sure we have it. Let me make sure we're, right now.
There we go.
Thank you.
Okay. You also need to do at least an annual review of your own compliance program. And you will need, again, assuming this goes into effect, a process for doing this. The OMIG used to have something on their website. We also have tools available. I'm happy to talk to you about it. It has to be carried out by the compliance officer, the committee. You can use external auditors or others who have expertise and independence. Here's something very interesting. They're saying that your review should include the following: on-site visits, interviews with affected individuals, again, pointing out that defined term, review of records and surveys, and then they did throw in kind of a catch-all or anything else that's comparable as long as it doesn't impact the integrity or independence of your internal review. It has to be documented, including how it's designed, how it's implemented, what the results are, what corrective actions you've taken, and it has to be shared up the chain of command with your CEO, with your senior management, with the compliance committee, and with the governing body. So again, taking it back to think about kind of a table of organization, you have this dotted line with the compliance officer, compliance committee, CEO, board of directors, all being involved, whether it's horizontal or vertical, seems to need to be worked out, but it's really trying to integrate it into the organization.
And hey, how many times over the years, right, do we have compliance officers telling us, oh, I don't have any real authority, I can't really get to my owners, I can't get to the C-suite, nobody really wants to. If you were ever given, you know, a club and some power, I mean, there has to be the full buy-in from the top, because if this stuff's not going to be going on and being done, you're gonna get popped. Right? That's the bottom line on that one. They're not gonna like that when they audit you.
Absolutely, absolutely. Turning to exclusion checks, one interesting thing here, I think most of you are probably doing this, should be doing this. You have to determine, identify and determine the exclusion status of, quote, effective individuals. So one important note, that does clearly go beyond your employees. Still has to be done every 30 days. That's been the long-time recommendation. The list that you need to check is somewhat interesting. They obviously put their own exclusion list, which is found on the OMIG website. They put the OIG's LEIE, list of excluded individuals and entities. That's found on the OIG website. They did not list the SAM, the System of Award Management, used to be the General Services Administration, list of debarred providers. Many of the contractors that our compliance folks use will do that. You know, I'm sort of on the fence. I think that it's better to check more than less, but at least in this case, OMIG is giving you a more narrow definition of what you're required to check. And again, mentioning that it has to be of contractors, agents, subcontractors, independent contractors. One way we're thinking about doing this, and we've recommended this in the past, is putting it in your contracts with your contractors, that these checks must be performed. And you can also talk about indemnities and things like that. And again, you have to share the results of the searches with the compliance officer and with appropriate personnel so that corrective action can be taken. Responding to compliance issues, I'm going to try to march through this really quickly. A lot of it is the same. Kind of highlighted in blue here, new requirements, or at least clarifications of existing requirements, taking prompt action to investigate and determining corrective action and implementing it promptly, documenting the investigation. And this is interesting. It's very specific. You have to include in your documentation the alleged violations, what process you took to undertake the investigation. You have to maintain all your interview notes and other documents, that you did a thorough investigation, and you're allowed to use outside experts. Some of that documentation, I'll note as an attorney, may raise privilege issues, so you may want to think about how you're going to document that and how you're going to secure those documents. Disciplinary action and corrective action obviously would need to be documented, and here's just one that is not quite sure what to make of it. If you identify credible evidence or credibly believe that some state or federal law, rule, or regulation has been violated, the proposed regs say you have to promptly report it to the government entity, and the compliance officer has to get copies. Now, I've been doing this, and Rob's been doing this for a long time. Nearly every compliance issue that we deal with is a potential violation of some law, rule, or regulation. I just don't see how this is workable, or quite frankly, from OMIG's perspective, enforceable. I think there's laudatory intent here. I understand the intent, which is, hey, we want you, as part of your compliance program, to report things that go wrong. And that makes sense. But I think this is one area that we're hopeful that the OMIG will look at in its comments.
Yeah.
Yeah,
sure.
Contracting.
Yeah, that one makes me
Yeah.
a little queasy, especially the
Agreed.
Fifth Amendment issue.
A lot of
issues coming up there. And as we keep also looking at the questions, so let me just make sure we've got everybody here. Let's see. For non-employee, we have questions about training obligations. Let me get right into this. We have one about, it says, for non-employed affected individuals, what is the training obligation? Contractors, 1099s, et cetera. Let's see, and then there's a more specific question. We'll try to get to that one towards the end. But so take a look at this, right? New contract requirement. Required providers must ensure that contracts with contractors, agents, subcontractors, and independent contractors who meet the definition of an affected individual, that is somebody who's touching your risk areas, specify that they are subject to your compliance program, and your contract must include termination provisions for the failure to adhere to the compliance program. Okay, so to answer your question is, you're really supposed to have, you're required to have these contractual arrangements where they agree to abide by your compliance program, which would require them to do the training and education. And mindful of time, the issues here are all over the place. And I've dealt with this issue, and I've dealt with this issue with OMIG, and I will tell you, it is very difficult. It's difficult to get, a lot of times you have necessary providers, people who are just providing services that you can't go without, oxygen deliveries, things of these natures come to mind, right? And I can't get it from somewhere else. They're not willing to sign my contract. They won't do my training. What do I do? So we're hoping that there's some more clarification here, but you're going to have to really come up with a set of training that's directed towards these individuals. And then the other begs the question is, who has to do the training? What kind of company is it? Is it a small company where just the owner does the training? Do multiple people have to do the training? We're hoping that in answering the comments that we get some more guidance here. There needs to be more clarity for providers and what happens if people refuse to sign these. Record retention, you have a 6 years requirement. So it has to demonstrate that you've adopted, implemented, and operated an effective compliance program. Has to be available to OMIG, MFCU, and DOH upon request. And that takes us over to, as we're cutting close to the end, compliance reviews. There's a provision in here that talks about OMIG's right to review whether or not you've adopted, implemented, and maintained an effective compliance program. They have to give you notice. There's timing requirements, and then they have to advise you on the outcome. You know, pass, fail, and then what? Are you subject to monetary penalties? It's possible. Or is your enrollment going to be terminated? It's possible. They've now also, further, kind of codified the self-disclosure program. Most of you are familiar with it, but the regulations are devoted to really implementing what they have in the Social Services Law and the Affordable Care Act. The duties remain the same. You're obligated to report and return overpayments to the government and to OMIG, and they've outlined, your eligibility and what you have to do. The eligibility is a little bit funny. If you're eligible if you're not under an audit, but if you're under an audit, but it's not that issue, you can disclose. But if you're under a criminal investigation for anything, you're not eligible. But by the way, even if you're not eligible, Peter, please disclose to us.
Yeah, and I think that last
I get it, but
I think that last point goes to where we started, which it's a harbinger of enforcement, right?
Yeah.
The 60-day time limit, for those of you who have discussed with us, we know it has its challenges. And they're saying here, you're eligible under these circumstances, but if you're not technically eligible, where we're going to give you the benefits of the self-disclosure program, and although it doesn't say it, I see it much like what the OIG does, you still have to tell us. And that's an interesting approach. Understandable, but interesting. Sorry.
Yeah, so, no, that's okay. Cut through this. And by the way, the question, can training be via computer or by video, or must it be in person? It can be by video. It does not have to be in person. It doesn't have to be a live training either. And, you know, and then we have, here's what you have to, your self-disclosure statement has to include. It's all your typical things, your explanation, the amount, the contact information. They're going to give us a data file they want us to follow, which we've been doing for years. And then there's these new compliance agreements, potentially, depending on how you're resolving the issues. But your statements now need to be signed by your compliance officer.
Yeah, I mean, I think these last two requirements, the must submit a self-disclosure statement, and if you flip to the next slide, the what they're calling a self-disclosure and compliance agreement, are pretty consistent with what they do now anyway. We always recommend that either the OMIG currently prefers the electronic form that goes to Gainwell, now used to be HMS, that has all that information. We used to do cover letters. We'll sometimes do that has all that information. As far as the agreements, they now call them repayment agreements or stipulation of settlements. Seems a bit similar. We'll have to see in practice. There's a 15-day turnaround time. I think OMIG generally uses 20 days now. So some changes. I guess we'll have to see in practice whether they amount to anything material or whether they're just adopting and tweaking what they're doing now anyway.
Yeah.
So I think that,
I think that's really kind of,
yeah, obviously, we all know, anyone who's talked to either of us or anyone at GW knows, if you don't report, return, and explain an identified overpayment within the time period, you have a lot of issues, potentially. Monetary penalties, False Claims Act cases, exclusion, you name it. So they make that clear in the proposed rules.
Yeah, we have this other question here. Are digital records okay when doing an investigation? Does it need to be hard copy? And then there's a comment whether digital can be seen by others as opposed to hard copy locked up. Well, you know, in my experience, and I know how you feel, I don't have a problem with digital copies unless there's a reason why the hard copy is a piece of material evidence. For example, it's been a handwritten item where you have forgery of some sort, or scanning and saving your investigation files. And in my experience, depending on your systems, they can be locked, and you know, security codes can be put in there. If there are material documents though that are in hard copy, or they're original type documents, those would need to be maintained.
Yeah, I agree with that. The one thing I would say about digital is I think about it in terms of OMIG audits. Obviously, there's a huge movement the last 10 years, 5 years in particular, to EMR. One of the things that the government will look for is show me the authenticity, show me who can access the documents, who can access the documents, that they're secure, that they haven't been changed. So if you're going to do that, you want to make sure the system is protected.
Then we have another question by, you're welcome, by compliance committee. Are we referring to internal? We have a compliance committee, a board audit and compliance committee, and then a full board. To me, this sounds like we're dealing with, you know, a large institution like a hospital or what. The chief operating officer and the chief financial officer are members of the internal compliance committee, and the activities reported to the board, audit, and compliance committee, no less than quarterly. Wanting clarity on compliance committee. I think, you know, there'll be some entitlement, maybe in the comments, to some clarity on that for institutions. In our experience, like if you're dealing with a health system, they have multiple levels, you know, even at different areas of compliance. I think they're talking about, though, that internal compliance committee that's made up of, you know, it's got your compliance officer with, you know, your managers. So you're not talking about a board level compliance committee at that point, and it's not going to be sufficient, as I recall the regs, to have a COO or CFO, or maybe it is, I'm not sure, do the reporting rather than the compliance officer. I'd have to look back to be
Yeah, I think
careful
for
about
a
it.
compliance committee and the proposed regs, their makeup, and again, the slides will be available after the presentation. The requirement is it has to be made up of senior managers. So they want people who are in a decision-making authority. Certainly CFO, COO, and affected individuals that are covered by the areas, depending on your institutional setup or your individual setup. One last thing on me. I think what I hope OMIG will consider as well is, I think that these proposed regs, again, it's very well intentioned, but are designed really from a perspective of large-scale institutions. And we have a lot of smaller providers that may hit the threshold, right? $1 million, even not $1 million, 2, 3, 4 providers. You know, does it really make sense for them to have compliance committees and this person and that person? It's 3 people. That, to me, is unanswered. There is no distinction in the proposed rules, and so we'll have to see how that plays out.
Yeah.
And I think we're just about out of time.
I think we're about done. How does this apply to social adult day care centers? This is a very specific question we have up here. I think you'd have to look, are you a required provider?
Yeah.
Depends on your, your reimbursement. Also, depends who's paying you. Tune in on January 19th for the next installment of our series, because that's, who are you signed up with? Are you contracted with plans? Because if you are, you're going to have compliance program obligations completely separate, although related, to what OMIG is doing here. So I know we have one question out there about the risk assessments. I'll have to look at that a little bit more carefully and respond. I can respond privately to you on that. But we thank you all so very much for your time, and we hope this was helpful, and we hope to see you all back here next month. And in the meantime, of course, Peter, how do we forget? We have these great pictures with our contact information. And so take it down, call us, email us, and if you want to watch the training again, or you need to share this with folks, feel free to do so. We'll be sending this all out, and thank you so much for all of your time. Have a great day.
Happy holidays and Happy New Year, everyone.
That's right.